You may proceed.
Good afternoon, Your Honors. My name is Joanne G. Swanson. I'm appearing on behalf of the Appellants Coalition Protecting Auto No Fault, Brain Injury Association of Michigan, and the individual plaintiffs. And with me today is George Gidding, co-counsel, as well as Judge James Gidding, co-counsel. Moving right to the issue that this court has identified for review, which assumes that the MCCA is a public body, our position is that MCL 500-134-4 does violate Article 4, Section 25 of the Michigan Constitution because it alters and amends FOIA without reenacting and republishing the affected section. And in advocating this position, we are not asking this court to substitute its judgment for that of the legislature or asking you to make policy determinations. What we are asking you to do is to enforce Article 4, Section 25 as it has been interpreted and applied by this court in Allen versus Wayne County. And Allen is a pivotal case because it decided a conflict in the law with respect to how strictly the legislature must conform to the requirements of Article 4, Section 25. Moak had held that if the legislature wants to amend a statute by placing words in another statute, the amended statute must be reenacted and republished. Contrary to Moak, Burton came along and held that no, the legislature can put words in one statute to amend another as long as the legislative purpose was made clear. In resolving the conflict between these two approaches, this court in Allen adopted Moak, overruled Burton, and said that the Constitution is not satisfied with halfway measures and does not prefer dissimulation to straightforwardness. Allen held that if one statute is intended to amend another statute, it must be stated specifically, and both statutes must be republished as contemplated by Article 4.
Counsel?
Yes. I meant to reserve 2 minutes. I apologize.
Okay, if you can. You're quite right. We did not focus on whether MCCA was a public body. But isn't that a threshold question? That if it is not a public body, this constitutional question that we've teed up here is irrelevant, correct?
If it is not a public body, then it would not be subject to FOIA. However,
and the constitutional exegesis over whether FOIA was amended in violation of the republication requirement would be irrelevant, correct?
you wouldn't have to reach that issue, Your Honor, if the MCCA is not a public body.
Oughtn't we resolve the non-constitutional question before we reach a constitutional question?
I think that would be wise. However, there are other non-constitutional questions as well that could avoid the need to have this court get here.
Okay. Well, I'm interested in non-constitutional resolution if I can get there. What would those be?
Well, for example, we argued in our application for leave to appeal, we made a statutory interpretation argument that 134.4 is not even the type of exemption that is contemplated by Section 13.1d of FOIA. Section 13.1d contemplates an exemption for records that are specifically described by statute. And 134.4 does not specifically describe records for exemption. It basically exempts according to the Court of Appeals, it exempts every document, every piece of paper possessed by the MCCA.
Okay.
So our position is, and by the way, I'd like to also point out that the Court of Appeals did not go through the Article 4, Section 25 analysis. But if you do take that analysis, which is directed by Allen, you will see that 134.4 does indeed amend FOIA, and it is not saved from having to conform and comply with Article 4, Section 25 as an exception. This court has recognized two exceptions to the application of Article 4, Section 25. Whether you call them exceptions or whether the analysis is that the Article 4, Section 25 is not reached in these instances is a matter of semantics, I think. But one of them is that Article 4, Section 25 does not apply if the amendment is by implication. MCL 134.4 is not an amendment by implication. It is expressly directed to FOIA. It is not incidental. It is not unintentional. FOIA is expressly mentioned in there, and the purpose of the entire statute, 134.4, is to exempt the MCCA from FOIA. The other exemption is whether or not 134.4 is an act complete in itself. In order to make that determination, this court compares the amending provision with the existing statute to determine which comprehensively covers the subject matter of the amendment. In this case, Your Honors, it's very clear that the subject of the amendment is the access to a public body's records and information, and 134.4 does not comprehensively cover that subject matter. That subject matter is covered comprehensively by FOIA. FOIA is the statute that determines the right of the public and allows the right of the public to access the records and information of a public body. The Court of Appeals treats Section 13.1d as a third exception, essentially, to Article 4, Section 25, holding that because the legislature basically gave itself permission to place exemptions to FOIA in other statutes, that 134.4 did not actually amend FOIA. Rather, the court said that 134.4 works pursuant to FOIA because, and I quote, the legislature drafted Section 13.1d in a manner to allow future statutory exemptions without the need to revise or amend FOIA. In other words, the Court of Appeals cast Section 13.1d as a valid legislative technique to bypass the duties imposed by Article 4, Section 25. There is no authority for this, and the legislature cannot, by statute, avoid its constitutional duty. Other than the voting booth, the Constitution is the only limitation on the exercise of legislative authority. And if the legislature can evade its Section 25 duty by drafting around it, Section 25 has no force. And this is a real problem for the citizens of this state and for the future of the state as a democratic institution. Because as Justice Cooley pointed out over 150 years ago, Section 25 was designed to remedy the legislative practice of making insertions and deletions in statutes to amend other provisions, which is confusing, it's imperceptible in many instances to the legislature, and also misleading to the public, who has difficulty discerning when the law is being changed, when it's not done in a straightforward manner.
Would the public have difficulty in this case understanding that FOIA, if you read FOIA, that you may have to look somewhere else to know what the extent of the scope of FOIA?
Your Honor, that isn't part of the record, and in this case, whether the public had difficulty or not, I think
I understand, but you quoted Justice Cooley, and that's a sort of the motivating concern of this provision that dates back a long time.
I think the Constitution requires it, irrespective of whether we come in here and prove that this actually happened in this case. If it's a constitutional, it was enacted in violation of the obligation to amend and republish.
How exactly did the amendment to the insurance code amend FOIA?
I'm sorry?
How exactly did the amendment to the insurance code amend FOIA?
It amended FOIA by wholly exempting the MCCA from the obligations of FOIA. When FOIA was enacted in 1976, there was no exemption for the MCCA.
So it changed its scope?
It totally.
There was a public body that it applied to before this and that it does not apply to now? Is that?
I'm sorry?
There was a public body that it applied to before the amendment that it doesn't apply to now?
MCCA is one. There were other associations and facilities that are also embraced by 134.4, so there are others as well, but
So
our
it-
folk,
But am I wrong to say that it changed, I'm trying to connect the word amendment, you're saying it amended it, therefore bringing into play Article 4, Section 25. And so I'm asking you, how
Well,
did it amend it? Am I overgeneralizing in some sense by saying that it changed the scope of FOIA?
I think that you're probably right in that sense, in the sense that,
Did it amend it in a different sense?
no, to the extent that every exemption lessens and narrows the scope of FOIA, yes, I think you're correct. Because I think this is an exemption that drastically narrows the effect. When you
What if the
immunize,
legislature create, in some completely separate area, creates a new public body? Has it also then changed the scope of FOIA such that it would have to republish FOIA every time it creates a new public body?
yes, and I can give you an example of that
Is your answer
happening.
yes?
Pardon?
Your
She said
answer is yes?
I'm sorry.
Yeah, yes, plus an example,
Okay, all right.
which we're waiting for.
My example is that in February of 2013, a bill was introduced in the Senate to make the legislature subject to FOIA. And that amendment was to the public body section of FOIA, and it went right into FOIA to amend the statute to make the legislature.
But my question's a little
Stop.
different. What if it somewhere else, completely unrelated to FOIA, creates a new public body to do some important public thing and never addresses FOIA at all? That would also change the scope of FOIA, would it not? Because now it
Well,
applies, instead of decreasing, now it increased the scope.
I don't think that would change the scope of FOIA because it's a public body within FOIA. It's not, it would just be a matter of identifying whether or not the public body whatever entity was created was in fact a public body. If it meets the definition of a public body within the meaning of FOIA, then that definition continues. Its scope
But isn't it-
realistically, its scope may broaden because the more public bodies that are created, the more rights and availability the public has to records and information.
It strikes me as odd that the one thing could be true, that it decreases the scope, and that's how it amends it, but if you increase the scope in that sense, you aren't also amending it. But I understand your point. Let me ask you a
But-
slightly different question. There's a lot of statutes out there that use phrases like "except as otherwise provided by law." And they're impacted all the time by other statutes that don't reference the statute that
And that's
is
one of,
referring to them. Do all of those changes always have to be, they have to republish the unrelated statute?
Your Honor, that language is not in FOIA, but the difference between the except as provided by law language and the issue that we have here is the purpose of using that language is as a technique to ensure that the law is not changing. It's telling the public the law is not changing because it's except as otherwise provided by law. It's not, and so the statute in which that appears is not changing the law, so it isn't triggered. It doesn't trigger the Article 4, Section 25 obligation, as in our case where there was a change in the law. And I don't know if that answers the question.
Well, the problem with that is, of course, is if the except as otherwise provided by law statute, that's not the one that changes. If the change is somewhere else, and some other change in some other statute that may then have an impact on the original statute, right?
I
So
think
the question kind of implies that there is a change that impacts the original statute, and so are all of those types of changes, that's my question, do those have the very same problem that Justice Cooley talked about, 150 years ago?
Well, I don't think it's the same situation because you would need to take a look at any other statute that is being advanced as having changed and requiring republication to determine whether it meets the Allen test, whether it's an amendment by application, or whether it's an act complete in itself. I think that language, though, is establishing that the status quo is remaining. We are not changing the status quo as to other provisions that are already in existence, except in the instance addressed by
I'm
the
going to
statute.
cut you off just so you can save a little bit of time for rebuttal,
Okay,
if you like.
thank you.
Is there any statute of limitation in this regard?
I'm sorry?
Is there any statute of limitation to challenges under Section 25?
I am not aware of that, Your Honor. I can't answer that question, but I'd be happy to prepare a supplemental brief on that issue.
Could
Just
I-
not aware
We
of
can
it.
do that, thank you.
Let me, oh, I get to keep it if I want.
That's okay.
Your argument, as I understand it, is the legislature violated the republication law because it directly attempted to amend the applicability of FOIA to the MCCA, correct?
That's correct.
So if the legislature said MCCA is not a public body, that would not have offended the republication rule, correct?
No, that's not correct.
Well, why can't the legislature define what is and what is not a public body without doing offense? Doesn't amend anything in FOIA, does it?
It does amend FOIA because when you have an entity that was a public body and is no longer a public body, that is changing the scope and making FOIA apply differently.
Well, yes, it does apply
Apply
differently, but
differently.
not because you've changed anything in FOIA. You've just defined the entity that may have been subject to FOIA as defining it outside the scope. So why is it, if the regime, the statutory regime that describes what MCCA is, defines it in a way that takes it outside of FOIA, why does that affect FOIA for the purposes of the republication rule?
Because it's changing the application of public body.
Only incidentally.
Not incidentally. It's changing it purposely. If it's purposely going into a statute to make MCCA no longer a public body within the meaning in FOIA of FOIA. And that is a defined term within
Yes,
FOIA.
but you're defining what is or is not subject to it.
And it's not incidental.
That's a very broad interpretation of direct effect.
It's not incidental, Your Honor, if the legislative purpose is to go in and specifically immunize the MCCA from FOIA. That's not by implication, that's not incidental or accidental. That's a purposeful amendment, and that is what
Purposeful isn't what the test is. The test is whether the legislature is affecting the statute in a direct way, not an indirect way, but I think I understand your argument. Thank you very much.
Thank you.
Sorry. Good afternoon. I'm Lori McAllister, and I'm appearing today on behalf of the appellee, the Michigan Catastrophic Claims Association, and with me are my partners, Joe Wheaton and Joe Earhart, who have also worked on this case throughout the appellate process. As I listened to Ms. Swanson's introduction, I thought she did a good job of identifying exactly the 2 points as to which we disagree. First of all, we do not agree that the MCCA is a public body in the first instance. We do not believe it was a public body at the time the legislature amended and adopted Section 134 of the Insurance Code. And I will go through that in just a moment. The other place, of course, that we disagree is the one that she said at the beginning and then also ended with in response to Justice Young's questions, which related to the issue of whether there was an amendment, alteration, or a revision of FOIA that was done by the legislature here that would even bring it into a situation where the constitutionality is a question. Why do I say the MCCA is not a public body? Well, first of all, I look at the statute that authorizes it, in particular, MCL 500.3104.1. In the text of the statute, it expressly says that this is an unincorporated nonprofit association to be known as the Catastrophic Claims Association. It is never defined at the time that it's created as a public body. And keep in mind that Section 3104 is enacted several years after FOIA is enacted. If the legislature wanted to make it subject to FOIA, it certainly had the roadmap from which it could have selected its terminology and the type of entity that it could have created. Also, at the time 3104 was adopted, FOIA itself distinguished between what a public body is and what an association is. This point was, I thought, nicely brought home in the amicus brief that was filed when they noted that Section 2 of FOIA, when you look at the definition under C, a person is defined to be a series of things, one of which is an association. But if you go to the definitions of public body, you nowhere see under subsection D that they have made that public bodies an association to be a public body.
Counsel, I just have a question, and what I'm trying to grapple with is it your position that the legislature can choose what is and what is not a public body?
I think that the legislature can, in the first instance, decide what is a public body. But I think the case law of this court, including in the League General case,
Could the legislature hypothetically say that it is in and of itself not a public body?
Well, I have difficulty buying that particular argument.
I understand,
and,
I
and
understand
I think it would
wouldn't
be
happen.
subject to review by the court.
Well, I understand it wouldn't happen, but under your theory, is that possible?
No, I don't think it is, Your Honor, because I think there are two tests, and they're the two tests that were adopted in the advisory opinion in 1976, and then again in the League General case itself. And the court in that case said, first of all, we look at the statutory definition to see if it is public body as defined in the statute. In that case, they were looking at the state agency definition. But secondly, we're going to look behind the labels and see what the entity does. And is it an entity that is funded by the state? Does it have state employees working for it? Does it have a situation where it has effect on the citizens where it can bind them to certain actions?
Doesn't
So
your agency
the
do those? But doesn't your
legislation would-
agency do those things?
Pardon me?
You just gave a test. Doesn't your agency do those different things?
No, it does not, Your Honor.
How is it distinguished?
We do not meet the definition of public body because we are a nonprofit association. We don't operate for a profit. We have no ability to even interact with ultimate policyholders. We are formed only for the benefit of the insurance companies and only incidentally benefit the public. That's what this court held in League General. We don't get any state revenues. If the MCCA goes broke, the MCCA goes broke. And
Are there
there's
any
no
requirements?
obligation for the state to step
Counsel, are
in.
there any requirements on me? Well, I don't drive. Thankfully, everyone should be happy about that. So thankfully,
We are.
we're not covered. Yeah, especially the chief did say I can drive his car later on.
Heavily insured.
But I guess the question I have though is that following that logic, do you have hypothetically on a person that is an insurance person or has a vehicle, does all this kind of stuff, do you have any ability, do you have any power over, is it your argument you have no power over the citizenry of the state whatsoever? You have no impact on the people of the state of Michigan?
That, to me, Your Honor, is two different questions. One is, do I have authority over such that I can compel action? And the answer to that is clearly no. The second question is, does it have an impact? And as to that question, I would say there is an incidental impact because the MCCA assesses insurers who then may consider that assessment in their rates. But, Your Honor, you could say that about virtually every corporation that has been formed in this state. It doesn't have authority to compel you to do anything, but yet the fact that it has certain rules that the state has set up that govern how shareholders elect directors, how many times they have to have board meetings, what kind of audit committee responsibilities they have to have.
Can an insurance
Those
company,
things
can an
all
insurance
impact the
company,
public.
can an insurance company choose not to be a part of this organization?
They may not.
Right. So they can't choose they can't choose to divorce themselves from this, correct?
That's correct. And that was one of the trade-offs that was made. But that does not mean in our position, Your Honor, that converts them into a state entity. The fact that they have to be a member of a certain organization is no different than telling, for example, that every employer in the state of Michigan has to have workers' comp insurance. That means that they have to go buy something, they're mandated to buy it, but it doesn't mean that it converts every employer into a public entity because they do
Counsel, help me
something
with
the
this, because
statute
help me with this, because
requires.
I'm a lawyer, and I'm a part of the State Bar Association. I have to be a part of the State Bar Association, and I'm regulated by the State Bar, and, you know, I'm impacted by the State Bar. Is that not correct?
That's my understanding, yes.
So how would this be distinguishable in terms of state action?
There is different things that the state action, well, first of all, Your Honor, I don't think we're dealing with the question of public body, which is what this statute requires us to look at. I think your question goes more to sort of a due process argument and whether there's a due process
No, I
issue
think
that's
I
here.
think he's asking whether you have the MCCA has the attributes of a public body.
And my answer to that is no. The Bar Association, I agree with you, does have the ability to require me to pay dues with very limited exceptions. But what the Bar Association also does is have employees that are part of the governmental budget, for example. This court has oversight over, for example, how much the Bar Association employees are paid, how much the attorney discipline board members are paid, et cetera.
Does the MCCA make a direct assessment on insurance in this state?
Never. We have no direct relationship with any policyholder. All we assess are the insurers, and it's the insurers that receive the benefits associated with the MCCA. And the reason I say that, Your Honor, is because in the event that the MCCA were to go broke, everyone would still have all of their rights to get unlimited PIP because they've purchased an insurance policy that gives them unlimited PIP.
Are the
The
insurers,
government is not stepping in to say,
are the insurers obligated to pass on the MCCA mandated amount?
they are not. The
So they may
statute says,
If MCCA says, we've got to increase our reserves so every insurer has an additional sum to pay, the insurance companies can absorb that amount rather than passing them on.
that's exactly right, Your Honor. What the statute says in Chapter 21, reading that together with Chapter 31, is that you can give due consideration to various expenses and assessments in determining your rates, but you are not required to pass along that cost.
Well, getting back to, I mean, we're talking about public body. Can the legislature define an entity as not being a public body?
I think that they not only can, but they have done it all the time without constitutional implications. I mean, FOIA itself gives
the argument I understood from opposing counsel is, if the legislature declared that the MCCA was not a public body within the meaning of FOIA, that would be a violation of the republication rule.
which I respectfully disagree with
And
her
why do you
conclusion on
disagree?
that. I'm sorry?
Why?
Why do I disagree with her conclusion? I disagree because even if it is deciding that it is not within the public body definition that's within FOIA, it still doesn't amend the Freedom of Information Act because of the way the Freedom of Information Act is set up. The legislature recognized that there could be exemptions provided by other statutes. And you can do one of those exemptions
Well,
without
just
amending,
before
altering,
you-
or revising the
Before you
statute.
get to that part,
Yes.
let's just say there isn't that legislative scheme here. That we're just talking about, if you're a public body, here's what FOIA requires. If the legislature in amending an act for another organization, here MCCA defines it in a way outside the scope of the FOIA, has the legislature in making that change violated the republication rule as to the to FOIA?
I would argue that the answer to that is still no, even if we were operating without the exemption language.
And why would
And
that
the
be?
reason I say that is because FOIA does not say this is an exhaustive list of what constitutes a public body. nor does it or the Constitution restrict the legislature from creating entities that are not public entities. Certainly the courts have an ability to look behind the labels and see what it is. That's what you held in the League General case. And you could certainly police the actions of the legislature through that mechanism. But I don't think, even in your situation where you take out the exemption language, that you would have to amend, alter, or revise FOIA in order for the exemption to be applicable and for it to be constitutional.
So changes as to what is or is not a public body, in your view, doesn't amend, alter, or revise FOIA. So what sorts of things would amend, alter, or revise FOIA? So scope of coverage doesn't seem to be included. If the legislature added another substantive exception, so exempting or adding entities is not an alteration of FOIA, but maybe we added some kind of different exception, I don't know, some new exception.
There is an exception that has been enacted in 2006 when private non-public health information was required by federal law to be something that was not disclosable. And so the legislature did go in that situation and say, we are going to amend FOIA to make it clear that these records, regardless of who holds them, are not subject to the Freedom of Information Act. So they thought it was appropriate in that situation
Did they republish?
to amend it, but pardon me?
Did they republish?
They
at that
did,
point?
they did republish in 2006. And so
And-
that is a situation
And so if they
with the
insert,
example.
if they insert then, instead of this new exemption for medical privacy, they insert MCCA, why don't they have to republish then?
Well, if they were to put MCCA in as an
Exempt.
affirmative, I guess at that point, Your Honor, I would be here arguing that what they have done is redundant because the MCCA was already excluded. And I think
Because,
the legislature, because they are an unincorporated nonprofit entity that has none of the indicia of a public body.
Okay, so
And that's what
that's
you
the
held
public
in
body.
League General.
so when the legislature says a record of an association or facility shall be exempt from disclosure of the Freedom of Information Act, that is not an amendment of the Freedom of Information Act.
That's correct, Your Honor.
Why would
We
that
do
be?
not believe that it is.
Why?
Not only because of the public body, but also because
Well, wait a minute,
of
that's
the
a different
exemption.
basis.
It's the exemption.
Oh, okay, but if
That's why
there's no,
we
if
say it
there's no
doesn't-
exemption,
If there's no exemption,
that-
then, you
that
know,
would
I
be a
probably,
violation.
I would have sat down 5 minutes ago if there was no exemption.
so you rely, your argument now, if FOIA is a public body, and this addition of an exemption for it would be an amendment, but for the legislative legerdemain of saying we can amend this at will without reference to the constitutional obligation.
That is my position, Your Honor. And the more extreme position that I have articulated today in response to the questions posed by the court are my views as to how they should be resolved, but I think the court needn't go that far. You only have to go to the language that's in front of you, and you can resolve the issues without having to deal with the constitutional issues.
And that is how?
Either through a determination that you agree that the MCCA is not a public body and therefore not subject to FOIA.
No one has addressed that subject until this point, correct?
Court of Appeals just is,
The court, it was not fully briefed in front of the court, but we never conceded it. In fact, I spent a lot of time
my point
asking
is-
Judge Gleicher's questions
my-
below on this very issue.
My point is very simple, it's mechanical.
Yes.
Before we reach the constitutional question of whether this statute is or is not a violation of the republication constitutional requirement, oughtn't we first determine whether this is an entity that falls within the ambit of FOIA?
Exactly, Your Honor, and that's why I started with that argument.
All right, now,
I think you absolutely must
shouldn't,
determine
in
that.
that case, shouldn't we remand this matter to the Court of Appeals for them to do that analysis?
Your Honor, I don't think that it is required to do that for two reasons. One, it's a legal issue. It's not a factual issue on which more information would be gathered by a
So
remand.
you think we should do that in the first
And
instance
I
without
think you-
briefing?
Well, Your Honor, if you want a supplemental brief on that, we would be happy to do that. I confess that when we saw the order from the court, I think both sides thought you wanted us to focus
I
on the
understand. I mean,
constitutional issue.
the thing that happens when we get cases, they fall.
And if, I would be thrilled to do a supplemental brief specific on this issue, Your Honor, because remanding it back, in our view, is not likely to be productive. Whoever loses is going to ask to be right back here to have the court decide it. As you can tell from the courtroom, this is in interest to the citizenry
Oh, I
of
thought these were
Michigan,
all
and we
here to
think
see
it
the
should
new
be
justice.
resolved.
Oh,
You know,
That
Counsel-
might be it.
Counsel, I have a question, and it's interesting, because I just asked Justice McCormick if there were people in the courtroom, because I wasn't aware that it was so busy. And this is the question that I kind of have for you, and I mean no disrespect in this question, but this is the thing I've really been trying to think about as it pertains, as I've gone through the litany of materials that have been sent. Why, when you're balancing this question as it pertains to the public body, the government, people's right to know, these types of issues, why is it so significant, and why is it so important to your client that you keep this information confidential? Why is it so significant that you don't release this material? I mean, are we talking about the Pentagon Papers? Are there launch codes? Like, why is this something that you are fighting so hard to keep this information secret from people or confidential?
I would answer that two ways, Justice Bernstein. One is we believe it's a valid act of the legislature and that they get to make the decisions on the policy question, and we believe that we should defend their choice in that regard. The second issue is this is a private entity, Your Honor. This is something that backstops the insurance companies. If you are insured by Allstate, for example, and Allstate should, heaven forbid, become broke, you as a policyholder don't look to the MCCA. You then get to look to the Michigan Property and Guarantee Association to pay your claim. The MCCA provides resources to insurance companies when benefits get into whatever the defined retention is of the level that causes catastrophic levels of benefits to be payable because of the nature of the injury. That is a private insurance company benefit that they receive that the legislature thought was appropriate for them to receive when they were issuing a policy that says we will pay all reasonable and necessary medical expenses for your lifetime. That was the trade-off for that particular type of benefit, was the legislature saying, well, we'll let you set up this backstop and essentially reinsure that risk. It's a private benefit for a private purpose. It is not a public entity that's controlled by the legislature or government.
Thank you, Counsel.
You're welcome.
thank you, the case is submitted. I do not believe you have any more time. Sorry.